Proceed.
Good morning, and may it please the court. My name is Jonathan Ellis. Ms. Riris will be here in a moment, who's also with me. We're with Shoemaker, and we have the pleasure of representing MANTABS LLC. If I may reserve 5 minutes for rebuttal, please.
Yes.
MANTABS is a small LLC that's primarily owned by the Salem family. It has one asset, which is a fourth-floor condominium overlooking the Gulf of Mexico. It had, and this suit revolves around MANTAB's ownership of a roof terrace that was 1,735 square feet, that overlooked the entire Gulf.
Help me understand, what is the ownership interest that MANTABS is asserting?
MANTABS is asserting, when you look at the declaration itself, that the area falls within the parametrical boundaries of the unit, and that would make it arguably a fee simple owner in the sense that it's a condominium and you just don't have it down to dirt.
Right. So I just want to make sure I understand, because usually with condos, when you're talking about the space of ownership, it's the surface walls in. So all the space and the surface walls in. Here, what you're really saying is it's the surface, well, not really the surface itself of the terrace, but because that is part of a roof, correct?
That's correct. So when you're dealing with a condominium, you're generally dealing with the parametrical boundaries of the unit. And so what you have is a general rule that the parametrical boundaries are from the unfinished wall in. So as soon as you paint it or you put wallpaper on it, the floors generally deal with what we call the slab itself until you put a flooring on it. The ceiling generally deals with the unfinished ceiling until you put paint on it. In this case, Your Honor, and you look at the parametrical boundaries when they're described, it's interesting because in this very specific situation, the deck is clear. And that is when it talks about the parametrical boundaries, it says unequivocally, in the upper floor apartments, such boundaries shall include the balcony serving such apartments, and there's a number of balconies.
I thought your argument was based on the fact that this was ambiguous. Did you just say it's clear?
I'm saying the language in the deck that I'm reading is black and white. There is ambiguities because when you take this and then you apply it to the diagrams use different languages. I'm sorry. The parametrical boundary description in the deck is clear, but that leads to ambiguities when you compare it now to the diagrams themselves. But it actually, yeah.
Before we get too much further into this, I just want to clarify for myself actually what we're looking at here, because there was a summary judgment that was granted in 2012. And then you all tried to appeal that, but we didn't have jurisdiction, so that appeal was dismissed. Then again, in 2016, there was a summary judgment that just reaffirmed what was done in 2012, but then made a determination that there was no prescriptive easement. And then what's on appeal here is from, I guess there was a motion to reconsider the 2012 and 2016 summary judgments, or alternatively, give us something final and appealable so we can resolve this. And the judge opted to just give you something final that just basically adopts what was done in 2012 and 2016. So what we're really reviewing, I think, is the 2012 summary judgment.
I think that's the issues there before the court.
So in deciding this appeal, I need to go back and I need to look at the motion for summary judgment and the pleadings and everything as they stood in 2012 and evaluate whether Judge Baird correctly entered summary judgment at that time?
I think, yes, Your Honor, with the exception, I think there was additional information that was filed by the time it went to Judge Schaefer. What had happened was there were still a few pending issues that were involved that were not resolved in the summary judgments dealing with damages that MANTABS was claiming as a result of damage to its materials that were on the roof.
Right, that was the counterclaims
Correct.
that are still pending, counts 1 and 2, right?
So what happened in that situation, I'm sorry, I'm interrupting you.
Well, no, I just want to, I'm trying to understand exactly what I'm reviewing, because, I think we're looking at a summary judgment that occurred at 2012, and I'm trying to evaluate whether that was correctly entered or not. And I want to understand if that's what the parties think we're looking at.
I believe that is what you're specifically looking at. There was a motion to rehear, and specifically, it had specific...
Which was denied, right?
It was ultimately, I'm sorry, the motion for rehearing was ultimately denied. The court looked at it and said, look, before we continue, we really need a roadmap on where to go forward with the earlier summary judgments.
I read that.
Excuse me, yeah, and as a result, let me give you a order of which you can take to the Second District Court of Appeal for guidance on how to proceed. Meaning the judge was having trouble. He reversed some of the judgments with respect, earlier judgments with respect to the injunction aspect of it.
Well, the parties agreed to that, correct?
Yes, had problems with it, said, look, let me put this to give you a judgment of which you can appeal this time, and then this is what you're looking at, and that is a rehearing of this earlier summary judgment dealing with the use of this large terrace.
And Judge Schaefer didn't do anything new in 2016 other than make the determination on the prescriptive easement. In other words, there was not any new determination regarding the issues that were decided in 2012.
I don't believe there was a new determination. I think the parties looked at it and realized you were not going to have a prescriptive easement over this area. The parties, based on the case law as it exists.
Okay.
So when you look at the ownership, Your Honor, and you're trying to figure out where it is, you're looking at what it states as the parametrical boundaries. And the parametrical boundaries, when you read it from the decks, states that in the cases of units 301 and 304, the boundaries shall include the roof terraces adjoining these apartments. And so that's why you have this. If you follow sort of where the parametrical boundaries are, that would, in our view, would be anything above the roof itself.
What makes this tricky conceptually and in practice is that usually those parametric boundaries for condos includes surface, right? The walls, the floor, the ceiling, so the condo owner you have something to touch. You can't really do that here because the roof surface itself is a common element. I mean, that's clear.
That's correct.
So you're arguing really that it's air.
That's correct.
Okay.
The answer is that you've had this exclusive use of this 1,735-foot roof terrace for 45 years, 35 years or 25 years by the Salem family on this, that you wound up having specifically to put something on it. There was a wooden flooring system that was placed on it that would not damage the roof. There were 2 gazebos, and this was all put up, not by the Salem family or their predecessor, but this was done by the developer, meaning this was part of when the building was handed over.
Is that a disputed issue?
I don't believe that is a disputed issue with respect to affidavits when you're looking at them from what was filed. I think there's remnants of disputed issues. I think there's disputed issues that Theochem and others may have changed part of this on the way, but I don't think there's any dispute that there were 2 gazebos in each of the corners.
No, I mean in terms of who constructed it and who made the opening in the wall, all of that.
I think there is some dispute, and I would ask, if the opposing counsel wants to put up where that is in the record. I think when you look at the record itself, the record's clear, and that is when you deal with the affidavit.
At the hearing in 2018, you all said that there was a dispute about who put the hole in the wall, who built the deck and gazebo, was there approval, was approval even needed? Did anyone from the association ever complain? And then you raised the issue of estoppel that Judge Baird never even really addressed that. So
I think those were...
That was your argument.
Correct. I think those were the answers, these were the items that were in dispute. I think when you look at the record itself, you're not seeing necessarily the specific affidavits from the association side where these items are each there. I think that was more argument on their behalf. They had the argument basically on the deck documents that this was in fact where they stand on the ownership. But the fact is that the knee-hole wall, and if the answer is there's facts, that would be an indication that this should not have been done on summary judgment, period.
Well, all of that... all of that really kind of falls within if this is ambiguous, right? I mean, none of that matters, including the letter that was once sent from the association attorney saying, oh yeah, you own it. None of that matters unless there's a conclusion that the description here is ambiguous.
If this court finds, as I think Judge Barrett indicated, that this is unambiguous.
That's in the conclusion of the judgment. This is
I
unambiguous.
believe then that the parole evidence doesn't come in. I don't think you can get there when you look at the declaration itself, because the declaration itself, back to your point, I think is conflicting, because when you look at the diagrams, what you see when you look at them is not anything that's listed as the balconies or the terraces as they should. You see roof over the third floor and you see sun deck, both of which can only be used if, in fact, it's the roof over the third floor and the sun deck can only be gained access to and can only be used through the unit. And that's where I think you wind up having a conflict. So when you turn around and you read the deck, it's almost like you had two different authors. One author that did the decks and that diagram, indicated what the decks were. And then you had another author that seemed to do the diagram and indicate what these items were, and the two don't match. That's why I think you wind up having issues of why parole evidence can come in. So when you start to look at two terraces, and in fact it does indicate, terraces, and this whole issue of whether the terrace is one terrace because it's dealing with 301 and 304, or it's two terraces.
It's mentioned in separate places. I get that.
Separate places,
Yeah,
but
yeah.
the fact is, even one of them mentions that there are, in fact, two terraces. And you really can't get to two terraces unless you now start to look at what I call the issues of the ambiguity. And what are the issues of the ambiguity? How do you fit two terraces when you're looking at the plat? We think it's the only way you can go is that the sun deck is one of the terraces, and the roof over the third floor is the second terrace. Opposing counsel of the association takes the position. I'm sorry,
Yeah, I have a question. I just want to clarify, because I can't remember. Is the plat referenced in the declarations?
Yes.
Okay, so what we would be looking at then to determine the boundaries would be the declaration and the plat.
Yes.
And if those are unambiguous, it's whatever they state. And if there's an ambiguity, then that's when we get into the parole evidence?
I think that's when
Or
we
is
get
there
into the...
something else besides the declaration and the plat that's part of the package that determines the boundaries?
The floor plan is also in there.
Is that referenced in the declaration?
Yes.
Okay.
So
Anything
all
else?
three of those items, and I think
So
if...
the floor plans, the plat, and the declaration?
And the declaration itself.
Okay.
That's where I think your world of documents are. So when you turn around and you look at this idea that how do you get two terraces, as it says in the declaration itself, how do you do that? If you take the association's position, the association, I think, recognizes a certain ambiguity. It doesn't even agree on how you get two terraces. One, they've taken the sun deck and they've cut it in half, which is not in the declaration. That's just something that they have done on their own. Or number two, they claim that there's a front balcony that counts as one of the balconies, and that's how you get there. But if you use that, there's no balcony reference for the other two, and as a result, the other two fourth floor units have no way to get in to their units outside of going through some ladder or something. So the question becomes, and this is the ambiguity, how do you get the language of the deck itself to turn around and unequivocally match, the diagrams that are setting forth what the floor plan is and what the plat is? The floor plan has its own set of problems because it doesn't even show the full floor plan when you're actually dealing with the balcony itself, or when you're dealing with the sun terrace, because it cuts it off before you even extend it all the way, and it doesn't show any indication of this cutting it in half as would be suggested by the association. So what you have is, on a summary judgment with this, after 34 years, 25 years by MANTABS, you wind up with MANTABS losing what was its roof terrace of this size. And this was...
Can you clarify a fact for me? Because, again, I'm not recalling precisely. But at some point, because of leak issues, the association removed the decking.
Yes.
And then they told the unit owners, you can't replace the decking. Is that correct?
Yes. I'm sorry.
Is that right?
Yes. The dispute arose because
And
there
they
were...
told them you can't replace it because it's going to create a problem with the roof.
Yes.
Not because you don't have the right to.
That's how it started, and then as a result, you got a deck action shortly after. What happened was the roof was leaking. The association believed that the association believed that the roof was leaking on one basis, and that's because of the decking that was on top of the roof. The association went in, they replaced the roof with a substandard roof. They told MANTABS you could replace it with a higher level roof if you want, but you have to pay it. MANTABS refused. They took the decking down, they replaced it. Now the roof is bubbling, they can't put the information on, and shortly after you get this claim for the declaratory judgment that they actually own the roof. Thank you.
Okay, thank you.
May it please the court. Webb Melton from Bush Ross on behalf of the appellee, the Happy Fiddler. Through this appeal, MANTABS seeks to convert 1,700 square feet of common element into fee simple unit by asking you to reverse numerous rulings over the years.
Do you agree that we're reviewing the 2012 summary judgment?
I think we're ruling both the 2012 and 2016. As you can tell by the record, there was probably over 9 motions challenging and forcing the court to relook at the issues raised by Judge Baird. There was also extensive discovery on this issue. One of the reasons this case...
Well, no, but we've got a motion and an order in 2012 that was because it only granted a motion for summary judgment as opposed to entering judgment, we couldn't review it. And so we dismissed that appeal. And then in 2016, my understanding is that all Judge Schaefer did is just adopt what was done in 2012.
I think there's some confusion. The appeal that was dismissed was done in 2016 after the Judge Schaefer ruling.
Okay, yeah, that one was dismissed. I thought both of these were
No,
dismissed.
no, and so that's what happened.
Oh,
Is there
only
was a
the 2016 one
correct. There was
dismissed?
4 years and over 9 motions. If you want to look at, like, for example...
Well, and you took the position in 2016 that because the counts 1 and 2 of the counterclaim were still outstanding, that's why it was a non-final order and that we should dismiss the appeal, but you're not objecting this time, even though they're still outstanding?
That is correct, just because the third trial court that was on this, Judge, we've had 4 judges actually review this, basically at that point in time was new to the case and we were about to go to trial. This was done at the pre-trial on that last count, and the judge would prefer to have this issue resolved because one of the issues in the case was conversion of those deteriorated deck pallets. So that's how we got there. But anyway, just to be clear, the Happy Fiddler is not trying to stop MANTABS from using this roof. Rather, what the Happy Fiddler is trying to do is to maintain it. This has proven difficulty. The association's president, Tony Martino...
Say that again?
We're not trying to prevent them from using this roof. We agree it's common element. Everybody agrees it's common element, and as common element, the parties have a right to use it as a common element.
But nobody can get to it, right, except the owners of these units?
Correct. That would be, yes. And just so the court's aware, I think it was brought up, the record does show on page 885 that the original blueprints had a firewall that actually, that cutout was added at some time after the declaration was built that gives access. But once that...
Wait. Where is that in the record? Because
It's page 885.
what is?
It's a copy of a blueprint that shows that the blueprints of the condominium called for that firewall to be built continuous.
But there's nothing in the record other than the affidavits from MANTABS that say how that opening got.
Correct.
Is
Because
that right?
yes, because at the time of the summary judgment, those were filed in response to our motion for summary judgment. So going back to
And as I read your motion for summary judgment, all you were arguing is that the roof itself was a common element and owned by the association, which they didn't dispute, and that seemed to be what Judge Baird focused on, and then somehow the space above it got thrown in.
They had also...
And I think they objected to that at the hearing, the discussion of that wasn't really in the motion, and they actually asked to have it continued because discovery wasn't done, and they raised that there were fact issues. I mean, there were all sorts of things that were raised at this summary judgment hearing in 2012 that really actually weren't addressed by Judge Baird.
And that's why, two things on that. First off, there were multiple motions at that hearing, and at that point in time, they were arguing this airspace argument. They had changed their argument because they want to make sure that the association maintains this roof. They realized after they filed a quiet title action, if they made it part of their unit completely, then the association would be responsible to maintain it. That wouldn't work for them, so they came up with this airspace argument, which allows them basically...
Well, but it was your motion that was granted.
Correct.
Okay, and did your motion actually raise that? I thought your motion just said, we own the roof, and it's a common element, and they said, yeah, we agree with that, but we're not talking about the roof.
Well, they, at the motion, raised the argument that for some reason, that the airspace above should be separate. Again, that was not any... I don't think that argument makes sense or really has any merit. So that's an argument they made at the hearing and in their summary judgment motion that was also heard at the hearing, and arguments they continued on through the 2016 ruling.
Perhaps the reason why there is some confusion here is we're both sides and the trial judge were all trying to cram a circle peg into a square hole or whatever you want to do. I mean, you can't be talking about fee simple ownership here, but what you could be talking about is a right of exclusive use.
And I think that brings us to the issue that we have here, or one of the issues is...
Well, it could, except the trial court made a ruling that there are no genuine issues of material fact concerning the ownership of the roof over the third floor and the ownership of the space above the roof surface.
Correct.
Which implies that, no, there is no dispute about exclusive use of it. This is common area, all of it.
Correct.
They don't have exclusive use.
Correct. That is what the judge was saying. And that is based on the declaration, and I think as Mr. Ellis pointed out, there's 3 provisions of the declaration that you need to review here. And you need to review all 3 of them together. The first is 4.3.
What about the plat and the floor plan?
That's in one of the 3, yes.
Okay, so those 3, you agree that those are the 3 things
Correct,
that
correct.
one would have to look at?
Yes, I think the most important are 4.3, Exhibit B, and the plat. And so just so you know, when you look at... and I don't know if you are able to pull up, but there's an aerial photo of the Happy Fiddler in your materials.
Right.
That actually has...
The one with the 1, 2, 3
Yes,
written on it?
It's located...
And you all wrote that on there?
That is correct.
Okay.
And I think it was cited in both parties' brief. That's to designate...
I think they objected to it.
I think they made a note and a footnote, but yes, it was in their brief as well, so it was in both parties' briefs. That being said, is that area, that's designed to show what those areas are. So that first part, that covered area where number 1 is, that's the covered balcony referenced in 4.3 of the declaration. That area number 2...
How do we know that?
Because I'm going to go through that when I go through Exhibit B and the plat. When you read all 3 together, that explains it. So that other area, which is the roof over third floor area, I'm sorry, that other area is marked as number 2 is the roof terrace that's referred to in 4.3 of the declaration. That's open air roof, that's terrace. The only thing that's protecting it from the only thing that's protecting the units below is that actual roof, which is opposed to the balcony. And just to put things under perspective, there's 2 identical units. On the other unit, which is identical, that number 1 space has been enclosed to make a sunroom. So taking that, and I think it's important to keep in mind that Section 4.3 states within its language, these apartments are described generally by reference, but specific reference should be made to the plans which are exhibits. And that's why the exhibits are so important in understanding what's going on here, because the exhibits show truly what is part of the unit. And the first exhibit you really need to look at is Exhibit B. And Exhibit B, what that is it shows MANTABS unit. And if you guys have the ability to find it, it shows a unit. It's got basically what looks like graph paper at the top right-hand side. It'll help if you have that in front of you as I'm talking. You'll see that when you look at that, you'll notice it shows the unit, and then it shows an area as graphed in there. That area is the roof, that is the balcony in parentheses terrace as referenced in 4.3.
Wait, I'm sorry, you just conflated
Sure.
the 2.
I apologize. So that area that's got the graph on it, it looks like graph paper, it's hash marks. Okay?
Right.
That corresponds with 4.3 to the area identified as balcony in parentheses terrace.
How do we know that?
Because when you look at all the documents, that's what it shows. So
It references a roof patio.
correct. The roof patio is the same
So
thing.
what's that?
It's the same thing as the balcony terrace. If you actually look at the plat and the exhibits, they seem to use
Where's the sun deck?
the sun deck is on the plat. So, so if
Is
you...
it on this?
It's not on Exhibit B. But if you look at Exhibit B, you'll notice...
Where is it, though?
I'll get to it. If you look at Exhibit...
I'd like to know where the sun deck is.
Sure. So if you look at Exhibit B, you'll notice it says roof patio 213 square feet. And it extends northward there after the graph paper, okay? So if you now look at Exhibit...
So it extends, there's something north that's not shown?
Correct.
So is there something east or west that's not shown?
What would be west would be the roof over third floor, that 1,700 square foot of properties in dispute. So if you now flip to the plat, which is Exhibit A, okay, and if you guys can find a picture of it, it's on...
We have
Okay,
all that.
great. So if you look at that, you'll see it says on there sun deck. And you can see the dimensions of the sun deck, okay? You can also see the area that's indicated as roof over third floor. So that area identified as roof over third floor, that's the roof over third floor that's in dispute. The area sun deck, we all agree, is part of their unit. Now, if you look at that sun deck, you can see the dimensions of it. It's 30 by 14 feet. That is 420 square feet. The difference between the 213 square feet shown on Exhibit B and that sun deck, that 207 square feet, that's the roof terrace referenced in 4.3 of the declaration.
How on earth are you getting that from the written descriptions that are provided here?
Well, that's because the boundaries of the condominium, and case law has hold, you have to look at the exhibits to the declaration.
Right.
In fact, when you actually look at the statute specifically says that when dealing with condominium, you define the units as set forth in the exhibits. The words are just kind of there to clarify things. And I want to draw...
Yeah, you don't get meets and bounds, I get it.
Right, and that's actually exactly what happened in the Shores of Panama Club versus Shores of Panama Resort case in 2016 out of the first DCA. They kind of faced a similar problem here. And what the trial court did in that situation is they had words, square footage, and they had diagrams, and there was a dispute over the front desk. Well, the trial court used the words and a meets and bounds description, but basically the general description in the words, to say that the front desk was, I believe they said it was not, they said it belonged to the club. Well, the trial court, upon reviewing that, said, look, we agree that these three things are unclear when read together, but when you look at them as a whole, you have to look at the most, you can look at the most specific one or look at the one that provides clarity, which in that situation was square footage. So they said that when the square footage is depicted, you should go with the square footage. So that's what Shores of Panama said. And Shores of Panama, brought some interesting points.
I think I could get on board with that if in the declaration it had said, like parentheses next to the terraces, which shall comprise of 420 square feet or what have you. I mean, because then you got it, right? Then you've got, all right, we now have an arguably undefined term, this terrace, mentioned in two different places. We have an as yet undefined term. We're going to look at the exhibits and the plat attached to it, but to help us figure out from the plat and the exhibit that's attached to it, we've got a square footage number that we can derive, that this was the intent when the declaration was recorded of what was being conveyed as part of each of these terraces, but we don't have that.
Yeah, I think if it was in the declaration, that would be great, but it would also be highly unusual because you don't include square footage in the declaration.
True.
What the declaration...
But this is an unusual situation where they're peeling off what they're trying to get the best of both worlds, right? They're trying to take what is otherwise going to be useless, valueless roof and turn it into something of value for purposes of the folks that happen to be adjoining it, and they're trying to do that in a way that, I don't want to say on the fly, but they're describing it as best as they think they need to.
So I would go back to 4.3 and what it says, and it says that, again, it tells us to look at the exhibits to the declaration. It says any ambiguity or any confusion, because it's just a general description, which is what you find in declarations all the time. The real boundaries of units are really shown in those exhibits that are attached. And if you look at those exhibits, in none of the exhibits does it show anything that suggests a 1,700 square foot unit is part of MANTAB's
Yeah,
unit.
but that's the thing. Like Exhibit B, for example, I get no square footage description whatsoever of any terrace, correct?
You do. You get the roof patio. So so the roof patio, again, what I think was going on there,
Which has what to do with the terrace?
well, they call it a roof terrace because it sits on top of the roof, so that roof patio would be covered. So it would make sense that they would refer to the roof part, which is the roof terrace adjoining the unit, or adjacent to the unit, would be that roof part that's not shown on there.
Okay, I'm looking at Exhibit B floor plan, right?
Correct.
And it's got the hashed marks. I think it's oriented where north is to the right. Is that correct?
I believe so.
Okay, so I've got hashed marks up in the northeast corner, right? Where are you deriving square footage up? Because the hashed marks continue on
Correct.
ad infinitum in two different directions. You've acknowledged that. All I've got is the bedroom wall on the, what would be the east part, and I have the sunken living area wall that would be on the southern part. That gives me potentially two lines, but it doesn't necessarily give me two boundaries because you've already said the hashed marks just go on.
Well, the hashed marks go on to the rest of the sun deck, which is 420 square feet. So again, when you look at how condominiums are constructed and how they're created, is they show what the units are in the plat. It's actually kind of unusual to have a floor plan like this, and so what the plat clearly shows is the boundaries of the unit. It shows that they have a 420 square foot sun deck.
If that's true, well, but if that's true, according to Exhibit B, they've got nothing. They've got no terrace. I mean, really, your position ought to be that there was no grant of any terrace, notwithstanding the master declaration's grant in two different places of terraces, because the floor plans that ultimately get attached really don't show what it is that the declaration purports to convey.
Well, I wouldn't say that because of the fact that the plat of the declaration shows what's included within the unit, and you have to account for that 207
So I've got
square
Exhibit
feet.
B showing me nothing, a plat showing me something, and a declaration conveying something. How is this not ambiguous?
If you look at them all together, and again, I think the other thing I'd also like to point out is if you look at them all together, I don't think you have an ambiguity because the way the declaration is worded. The way you can, and let's also back up here too, declarations are not like mere contracts. They spell out the rights of what people own. When people in the Happy Fiddler bought these units, they relied on what the declaration said. And if you look at 4.3, there is an interpretation, and this interpretation does make all the provisions and exhibits comply and work together. It would make sense that when designing the building, they would mark both the interior area and they would mark both the exterior area. It would also make sense that when defining where the roof patio is, and when you actually look at the term patio and balcony on the plat and exhibits, they use those interchangeably, so it makes sense that they would refer to it as a roof patio, roof balcony. I think they thought it was one and the same. So when you look at all those together, the only logical conclusion that allows you to read 4.3, Exhibit B, and Exhibit A together is that 420 square foot roof terrace is comprised of the two sections set forth in 4.3 of the declaration. And the other thing I'd like to point out is Exhibit D to the declaration.
Let me just back you up a minute. I may have missed this. What did in 4.3 it says the roof terrace on the roof adjoining the apartment. Now, what do you say that refers to?
That's the area listed as number 2 on that aerial photo, and also the 207 feet of roof space that would be shown on the sun deck.
Let me just take you to the plan, because this 4.3 says reference should be made to the plans.
Mm-hmm.
Okay, so on the plan, where is the roof terrace on the roof adjoining the apartment?
Are you referring to Exhibit B? It's indicated by showing those continuing lines, as opposed to ending those lines on Exhibit B. So it's showing that there's more there. And that's why it also shows a 213 square foot roof patio. Why they didn't include the terrace on there as a separate item, I do not know. But there's also one other exhibit to the declaration that we need to consider here, and that's Exhibit D to the declaration. So it's undisputed that MANTABS has never paid assessments for the roof over the 1,700 square foot roof over third floor. And according to the declaration, sections 4.5, 6.1, and Exhibit D, and most notably 3.2a, which says that if the developer changes a unit in size, he must amend Exhibit D. And what Exhibit D is Exhibit D divides how the parties share in their assessments. And so I want to point out what the assessment shares are. So if you can bring up that plat again showing...
Well, hang on, because now you're going outside of what's in the documents, which you've said, no, they're unambiguous, so we don't look outside of them.
No, Exhibit D is part of the declaration.
Oh, okay.
Yes.
All right,
But
sorry.
the fact of non-payment of assessments isn't.
I think it goes...
That is parole evidence.
No, I don't think it is parole evidence, because it goes to show how the document was drafted altogether. Because it shows that the draft of the document never included the 1,700 square feet as part of the MANTABS unit. Because if they had, they would have included it within the
Fine,
square
that's what
footage.
Exhibit D says what it says, but you went a step further and said, and by the way, they've not paid the assessments on this area. That is parole.
Oh, correct, to that extent,
Okay.
correct. Well, and the reason and it's not it's not because that it has to do with the fact that they paid the assessment share as set forth in the declaration. That is correct. Thank you for correcting me. So if you look at those two units, you'll see four units on the top of the roof of the Happy Fiddler. You'll see 402 and 403, which are in the middle, and then 401 and 404, which are on the outside. Those are the two units that that have the roof over third floor next to them. So if you look at 401, and I'm sorry, 402 and 403, and compare them to 401 and 404, you'll see that they're roughly the same size. The 401 and 404 are slightly larger when you add in the sun deck. Well, the percentage of the assessments allotted to them based on square footage of their unit is 4.24% for each of those two in the middle, and 5.17% for each of those two on the outside MANTABS unit. And that would make sense with an interpretation that the documents and the exhibits in 4.3 and all this includes the sun deck and the unit only as part of MANTABS unit. But what they're trying to get you to do is increase the unit to include that 1,700 square foot roof terrace. And
Well, I think what there are, I'm sorry.
So I was just going to tell him his time is expired, but I'll give him another minute. It seems like I guess right that something else was coming.
Just real quick, I think, I'm not sure that your argument makes sense in terms of what it is they're asking for, which was just exclusive use. I don't think they're asking for, or maybe I'm misunderstanding what their argument is. I don't think that they're asking that roof area and the solid surface is part of the condo unit itself. I think they're just saying we have a right to put decking down, we have a right of exclusive use. That's it.
Yeah, what I think they're really asking for is what we call in the condominium rules a limited common element, which is a portion of the condominium common elements which is subject to exclusive use. The reason they can't ask for that here is because of the fact that the statutes, whatever version you look at, and case law is very clear that the documents must specifically identify those limited common elements. Here, the developer knew what limited common elements was. He identified elevators as limited common elements in 3.5b and 5.3 of the declaration. So if he intended to have some sort of exclusive use area over the roof of a third floor, he could have done it as a limited common element, which is what he was clearly aware and knew how to do and chose not to. I thank
Before you go.
Yes.
In talking about the limited exclusive use, is the count for prescriptive easement still pending?
That issue is resolved.
That has been resolved.
Correct.
And that it would be outside of our record?
Correct.
Okay, thank you.
Well, it would be in the record, but outside of the briefs.
Okay,
Thank you very much.
thank you.
What's being asked for is exclusive use. And the problem you have when you look at it is that exclusive use comes from the fact that it was defined as being in the parametrical boundaries of the unit. And that's where you're getting this problem, and then when you apply it to the various diagrams, that it's just not fitting easily in any type of single analysis without making different assumptions and different conjectures. But by the time you do that, that means it's not ripe for summary judgment. And that means there ought to be some trial where all the evidence comes in and some judge makes a decision weighing all of the evidence that's before it. And that's why we're asking for the summary judgment to be overturned and have all of the information come in and have a judge make a ruling based on that aspect of it. Because even when you're dealing with opposing counsel's argument, you wind up getting a number of different assumptions where you can't track it from point A to point B. You can go by the fact that the assessment scheme was based on the square footage of the unit, but that's not indicated anywhere in the declaration itself. There is nothing that says this is based on the square footage of the unit. In fact, it's amended a number of years later because it doesn't reflect the square footage of the unit. you can start to say the sun deck is one of two items, which the sun deck is really the two terraces, but again, it doesn't say that anywhere in the document. You need to go by conjecture, and you need to go by the fact that council decided to arbitrarily draw a line on the sun deck as it's shown in the plat. Those are where the problems arise. You talk about the fact that 4.3 says you really need to look at the plat and at the floor plan or at the exhibits. But the fact is 4.3 is unequivocally clear, understanding where we went before, and that is that there are two terraces, that there is a balcony terrace, and that there is a roof terrace on the roof adjoining the apartment. And when you look at the plat, there's only one thing that's mentioned as a roof adjoining it, and that's the roof over the third floor. And when the problem you have, and this is the problem I think MANTABS is having, is that there is no unequivocally clear, as you start to go down each one of these rabbit holes, you wind up having what we call is messy, and as a result, the parole evidence comes in, and when the parole evidence comes in, there is a solid agreement up until the roof needed to be replaced. The association's council said it belonged exclusively to MANTABS. The association, through Mr. Martino, said it belonged exclusively to MANTABS. The developer said it's for the exclusive use of those unit owners, and the association said it was for the exclusive use of those unit owners. So as soon as you bring the parole evidence in, there is light on how this is to be interpreted, and that is the fact that this is supposed to be exclusive use by those two units. And I think you're right. It takes what is really dead space and turns it into a terrific accoutrement of these units, which is now lost. So when you have MANTABS looking out on the Gulf, it sees a peeling, bubbling roof, as opposed to the picture that you had in there that showed the decks. There are a couple of pictures that show that it looked like it was under construction. That was after the association started the construction on the roof. That is not how it looked while it was being used by the unit owners. The what?
There are pictures of it intact.
Yeah, and that's what you're using. So you buy this unit, you have that for 25 years, and you wake up one day over a dispute of whether there's any damage to the roof or not, which I think ultimately is determined as caused by the vent pipes going to the lower units for the sewer lines, but that you wake up one day and you've lost that entire aspect of your building. And while they say, look, we're not asking for no use, the fact is you can't use it unless you put something on top of it with the way that it currently is, and there's no trespass signs that were up there after it was done that were directed at MANTABS. So this idea that they could continue to use this to walk on a hot peeling roof is, I think, is a little bit disingenuous. Fact is that MANTABS had this 25 years. It is an incredibly important aspect of that entire condo. They entertain on it. They bring people aboard, and all of a sudden it's gone. And I don't think, and its problem is that you never get this beyond a summary judgment aspect. And I think it's clearly and unequivocally ambiguous. Thank you. So we're asking this court to overturn the ruling and remand it to the trial court based on ambiguity, based on the fact that it's not a proper summary judgment. Thank you.